Thank you all so much for joining. I know that we will still get a couple more people over the first couple of minutes. So as we give them a chance to join, let me just say welcome. My name is Stacey Gray. I'm a senior counsel here at the Future of Privacy Forum, and very fortunate today to be joined by my new colleague, Rachele Hendricks-Sturrup, who has recently joined FPF as our health policy counsel and expert on all things health science, health research, and a lot of what we're going to be talking about today. Before we begin, I just wanted to quickly say what we're doing here. FPF has recently launched a new privacy legislation series of webinars, of which this is the second one. So we're very excited that you've joined us. And our basic goal for these webinars is to provide more resources for all of the legislative staff out there and all of the other public policy experts who might be longtime lawyers or longtime legislative experts, but perhaps new to data privacy. And as we do that, a big part of our goal is to explain some of the differing perspectives from advocates, scholars, and industry, where they align, where they're different. FPF supports a federal comprehensive privacy law. In the meantime, there are a lot of state legislative efforts ongoing that we want to be supportive of as well. And our mission is to bridge some of the policymaker, industry, academic gaps in all of this conversation. Here's our website link, of course, fpf.org, and you can find legislative resources specifically at this link here. We have a couple upcoming sessions that you might want to be aware of. Our next one is going to be on December 19th on the topic of preemption, which is, of course, a very hot topic, very important specifically to the federal debates that are going on. But we'd also like to talk in more detail about other aspects of comprehensive privacy laws. We're going to discuss child privacy with our education team, geolocation as a concept that many regulators are trying to grapple with, and maybe public records and First Amendment issues. If you have ideas, send them. We would love to hear from you. And again, all the resources and all the links, including the video and the slides from today and all of the other sessions, are available on our website. So with that said, here's our agenda for today. We're going to spend about 45 minutes talking through these topics, and then we're going to leave about 15 minutes for Q&A at the end. And just as a housekeeping note for those of you who are looking to participate, we have a live Q&A chat box function. So as we go along, please, if we say something that doesn't make sense, feel free to jump in with a question in the chat box and we'll try to answer it in real time. And if it's a big picture question, feel free to leave it towards the end and we'll get to it in Q&A or some combination of both. Everyone on the webinar is muted by default, but we are paying attention to the chat function and welcome questions there. So we're gonna, like I said, we're gonna spend 45 minutes or so talking about these topics. We're gonna walk through a couple of the things you need to know about traditionally regulated research. That's, of course, the topic for today is commercial research and how privacy laws impact it. And so I think to understand some of the legislative gaps that regulators are trying to fill, first you have to understand what's already out there, right? So my colleague Rachele is going to be talking through some of the traditionally regulated research and what that looks like. Common rule, the revised common rule, we'll give some examples of emerging non-traditional research. And then we're going to come back to me and I'm going to talk through some aspects of comprehensive privacy laws and how those specifically impact research. We're going to look a little bit at federal proposals. It's a little bit informed by the CCPA. I know many of you are looking at that. We're not going to get into HIPAA and FERPA. Those are of course big things. And we're going to talk a little bit about the GDPR as we go along too. Okay, so sources of law and regulations, very big picture, 1,000 feet. You've got to know that there is existing regulatory and legal oversight for health and biomedical research, which Rachele will talk about. You've got the HHS overseeing federally funded research with the Common Rule. You've got the FDA overseeing pharmaceutical research, medical device research. You, of course, have HIPAA, our US sectoral law governing healthcare entities. but not necessarily data in some forms once it's been released from healthcare entities, right? And then in the background of that, the FTC has consumer protection authority over commercial entities. Like I mentioned, there are other US regulatory frameworks. So anytime you have a sectoral framework that governs privacy of information, you're probably going to have an effect on researchers who would like to use that information, right? But we won't be getting into FERPA and COPPA today, but just to note that they're out there. And then of course, in contrast to the United States' sectoral approach, the GDPR has recently come into effect with in the last couple of years, and that is a comprehensive privacy law that applies to all sectors and all technologies and has specific provisions for research. So that's the high-level overview. Rachel, awesome. let's kick it off. Tell us a little bit about traditionally regulated research.
Yes, absolutely. Happy to take it from here to continue our discussion at the top of our agenda on existing legal frameworks for health and biomedical research. Quickly, before I get started, thank you, Stacey, for the warm introduction. It's my pleasure to be introduced and also introduce myself to all of our attendees. It's a pleasure to be Health Policy Counsel at the FPF and engage all of you today.
And Rachel, you have some background in the issues we're talking about, right? Do you want to say briefly what that is?
Sure. So my background in particular has focused, or I continue to focus on, I should say, on matters pertaining to biomedical research around precision medicine efforts. Also within that, specifically looking at ethical, legal, and social issues that remain at the center of health policy as it relates to precision medicine research endeavors. Also examining implementation issues, one of which from an external standpoint could be associated with regulations that are in place to actually support investigators and research participants, sponsors, whomever might be engaged in these kinds of efforts. So there's certainly a lot of overlap here. We will kind of get into some detail as an example about how my particular focus on precision medicine overlaps with our discussion on commercial research. So looking at our slide here, examining some factors associated with traditionally regulated research, as you'll see in the first bullet point, pharmaceutical industry research, which is the most popular, at least over the last few decades, that line of research is regulated by the FDA. The FDA oversees the development of drugs, medical devices, supplements that can be prescribed by clinicians. And also research conducted by investigators at HIPAA-covered entities are governed by HIPAA. And data that's generated or collected by covered entities would fall under the purview of the HIPAA privacy rule. And also research conducted by investigators at academic institutions, which is also very common. It really depends in terms of rather what regulation oversees that research. It really depends on who's the sponsor of that research. If it's federally funded, for example, the research is subject to the common rule. Almost all of the time, research conducted at academic institutions requires IRB oversight and approval. And academic institutions or their investigators within have the liberty to partner with private companies or external entities. And all of this, again, is still subject to the academic institution's IRB, and then separately contractual obligations between the researchers, the sponsor, and the institution at which the research is occurring or taking place. Now, our next slide just gives you some examples of emerging non-traditional research. Given that technology has allowed entities that are considered non-traditional research partners to collect, process, assess, and share all types of data that can be health-related or have implications in healthcare. Considering that the technologies are allowing these entities to engage in research, we are starting to see at an unprecedented level research emerge from these entities. For our first example, we have independent research conducted by private companies. In the screenshot I provide here, this private company in particular, as an example, is 23andMe. They conduct their own research, they sponsor it, use their own data, use their own scientists, and draw conclusions based on the data that they've collected and the research questions that they've been able to pose and answer based on the analysis of the data that they have. And keep in mind that these kinds of companies are not considered HIPAA covered, as we saw in the previous slide. So essentially, that company is at liberties to engage in the research or engage in institutional review board activities at their will. So separately from that, it could intersect or cross over with commercial research, is citizen science research, or research conducted independently by citizen scientists. It could have commercial implications, it could not, but we certainly want to consider this, this level of engagement in this discussion today, because it's certainly another form of non-traditional research that's taking place. And the topics of citizen scientist research could be on medicine, computer science, statistics, psychology, and also genetics. So certainly there are implications there that, that would require some level of ethical review, although it does not in these cases. And these studies, keep in mind, conducted in these non-traditional research settings, they can be cross-sectional or looked at one point in time, or longitudinal across several years. So there can be immediate consequences and also long-term consequences.
We had a question in the chat about, let's see, commercial enterprises that are conducting wellness programs, for example. And I think this is a good example of what you're talking about, Rachel. So to the extent that they're not partnering with an academic institution or a HIPAA entity, they wouldn't fall under any of the existing US sectoral regulations or laws, right? Although there might be some FTC oversight related to unfair and deceptive business practices, but beyond that.
Absolutely. So, so Stacey and I, you and I have chatted at length about what happens around the if and when. The answer is always, it depends. So this is a great question. It's actually aligned with a lot of research that I've done and that I continue to do. Wellness programs can be offered by insurers who are covered entities. So therefore, any data collected about individuals under wellness programs by the insurer would be held by the insurer as a covered entity and thus protected under HIPAA. However, if the data is collected by an employer, now an employer is not considered a covered entity under HIPAA. There are other regulations in place to protect employees from the disclosure, or from unauthorized disclosure or discrimination on behalf of employers in the event the employers take action on that information. One example of that is the Genetic Information Non-Discrimination Act. If an employer provides a wellness program as a benefit to their employees, and that wellness program involves the collection and use of genetic information, either in individual form or summary statistical form, then that individual would have protections under the Genetic Information Non-Discrimination Act from that employer. So that way there's some protection, or there's some knowledge that there's a law out there that the employer cannot discriminate against the employee based on that employee's genetic information. There are still gaps there, again, because an employer is not a HIPAA covered entity. So in the event the employer collects health information on behalf of a single or many employees, there are other considerations to consider from a regulatory standpoint. That's definitely a topic of discussion, probably for something in the future, and happy to collect anyone's interest on talking more about that, and also happy to answer that question right now. But I'll go ahead and move forward with our webinar agenda. So just some high-level information about the Belmont Report and the Common Rule. The Belmont Report was written in 1979 by the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research. This particular report inspired the development of the Common Rule in 1991. And in fact, from there, the common rule and IRB system themselves as operational units was a regulation and subsequent an operational unit being the IRB system. They were born out of outrage over historical events, particularly the US government's decades-long Tuskegee experiments conducted in the 1970s or finished in the 1970s after the study became public. In that experiment, African-American sharecroppers were left untreated with syphilis as a way to study the disease progression, although the sharecroppers were under the impression that they were receiving treatment. So there are certainly some ethical considerations here, and again, oversight bodies like the IRB were born out of this, what was argued as negligence on behalf of health researchers. So there are ethical tenets in the common rule that the IRB seeks to uphold, and that's at a high level respect for persons, beneficence, and also justice on behalf of research participants who have consented to engage with researchers in any biomedical or behavioral research. Now, moving to the next slide, the common rule was in fact amended or revised in 2017. So just very recently to modernize or strengthen and make the common rule more effective as it pertains to the broader types of research taking place out there under the common rule. One major thing to consider is that the revised common rule actually retained wording from the pre-2018 definition of research, but it explicitly removed 4 categories of activities from activities that would meet the definition of research. And these, I won't go into them in great detail, but as many of you can see here, these 4 categories that were removed were research that involved the use of educational tests, surveys, procedures, interviews, and so forth, research involving the collection or study of information that has been or will be acquired solely for non-research activities, also research conducted by a federal government agency using federal government generated non-research information when certain criteria are met, and then the 4th, research regulated as healthcare operations or public health activities or research covered under HIPAA. So moving to our next slide, speaking of research conducted under HIPAA, this is an overview of what that looks like. Under the HIPAA privacy rule, research is defined as a systematic investigation, including research development, testing, and evaluation designed to develop or contribute to generalizable knowledge. This definition is widely adopted by many agencies, including the National Institute of Health. And under HIPAA, the HIPAA privacy rule, there are conditions under which protected health information can be used or disclosed by covered entities for research purposes in particular. These considerations are outlined here, well, not considerations, but rather these conditions. The first one that I have listed are there must be documented institutional or IRB or privacy board approval. There must be representations from the researcher, either in writing or orally, that the use or disclosure of protected health information is solely, or PHI, is solely to prepare a research protocol or other necessary elements to the research. A data use agreement must be in place for limited data sets that are exchanged in the process of research or in the conduct of the research. There must be authorization from the research participant to disclose the protected health information. And also, if there's a need to account for research disclosures in general, I guess from an auditing standpoint, that's also a condition under which protected health information may be disclosed for research purposes. So going to our next slide, talking a little more about institutional review boards and what their duties look like as they consider the ethical tenets under the common rule. We'll define first what IRBs are, and they are independent bodies that oversee the highest ethical standards for human research protections in all human subjects research and adherence to ethical principles outlined in the Belmont Report, which you saw in our previous or a slide before, last. And so some factors that IRBs consider in practice under the common rule are what you see here. It's whether or not, first, the study involves human subjects, what the intervention is and what the scope of that intervention looks like over time. Conducting a benefit risk analysis. Do the benefits outweigh the risks to the study participants? What are those expected benefits? What are the risks? Risk can be physical risk, social risk, for example, reputational harm to the participants, the investigators, and also the institution. The ethical principles that we mentioned before are considered in all decisions and factors that are gathered as part of the research. And those ethical principles, as I mentioned, are beneficence. Another in general in ethical in biomedical or bioethics is non-maleficence, also considering the Hippocratic Oath of do no harm. Participant autonomy. Will individuals have the ability to consent to any interventions that are offered to them in the event the research is brought to them as an option? Also, who are the populations involved? Does the research involve vulnerable populations like children or prisoners? Does it involve pregnant women? Does the study have an adequate representation of the population in general if the study is in fact a population study, for example, gender, race, ethnicity, age groups? If it does not have an adequate representation of the population, why? There could be a scientific case for that, so the IRB certainly considers that. And they also consider other risks that are internal or external, such as financial conflicts of interest and also environmental impact. So with all of that being said, as we're seeing research emerge from non-traditional sectors like citizen science research, research conducted independently by companies who collect and process their own health information, there's an emerging role of ethical review boards, privacy review boards, consumer subject review boards, and also some data safety monitoring boards. We're seeing an emergence of growing importance of these types of review boards. IRBs are sometimes referred to as one of or many of these review boards that you see here, but in general, the concept of these review boards that you see here are showing up in legislative proposals. And Stacey has been astute enough to recognize that, and we'll talk about this in more detail moving forward in the webinar. So thank you all very much. It's been a pleasure to talk about these topics with you, and I'll hand it over to you, Stacey.
Excellent. Thank you, Rachel. And Rachel's not going anywhere. She'll continue to be here for
that's right,
for Q&A. And like we mentioned, feel free to pop questions in the chat if you're just joining us. We're gonna sort of turn a page here for just a moment and talk about some of the federal proposals that we're seeing, some of the emerging comprehensive privacy laws that we're seeing, and some of the elements of them and how it might impact the kind of research that you're talking about, Rachel, when it's emerging, when it might not be regulated directly by HHS or the FDA or some other institution. And of course, if you've been paying attention in the news lately, you've probably seen a great deal of activity towards the notion of passing a comprehensive baseline federal privacy law in the United States. You may have actually seen many proposals. There have been up to, I think, by our count, 10 proposals introduced in Congress in the last year, not to mention all of the model bills from civil society and industry. The last week was really a turning point, though, because we saw proposals introduced by leaders in the Senate Commerce Committee. And given the influence of the Senate Commerce Committee and the fact that these were the first proposals from Senate Democrat and Republican leaders, just the last week in activity has represented a major turning point towards actually passing something. Whether it will look like one of these two bills, not clear, but certainly we're making progress. And when we talk about a comprehensive federal privacy law, we're really talking about something that is technology neutral, that is non-sector specific, like most of the privacy laws that exist in the United States. and that may or may not to some extent supersede some of the state privacy provisions that we're seeing come into place. So one of the first things that legislative staff and policy experts have to consider when we talk about a comprehensive privacy law is first, how is it going to interact with the existing law that we already have on the books? And so the impact on existing federal frameworks is a starting point for a lot of this discussion. What we have seen with, I would say, almost all of the proposals, if not all of the proposals, and certainly the two bills introduced or disseminated in the last couple of weeks, is that most of them leave the existing federal sectoral frameworks around traditional biomedical research and health research intact. Nobody seems to be interested in superseding HIPAA, although it could be done, right? But you know, it would be quite a cost. So what we've recommended to legislators when they're considering how to supersede or not existing federal laws is to consider a few things. You've got to consider compliance costs. For example, if there is an industry with an entrenched regulatory framework that's been in existence for decades, it might be a tremendous cost to supersede that kind of thing. You also want to consider whether there is a federal agency or not that has built up many, many years of deep expertise. For example, HHS unquestionably has deep expertise in these issues that might be hard to say, you know, transfer over to the FTC or some other new federal agency. And then you also, of course, want to consider whether you're dealing with a uniquely situated set of business practice or uniquely situated users. A good example of that, I think, is the Children's Online Privacy Protection Act. So children are a unique population of users, I think, by most accounts when we're talking about privacy laws. And so none of the federal proposals that I've seen would be interested in superseding CCPA, which applies to data collected from anyone under the age of 13. So with all of that in mind, what we're really talking about is the way that a comprehensive privacy law would impact all the rest of the non-traditional and non-traditionally regulated commercial research that is out there. The second big thing, which we're not going to get so much into, is, but of course you have to consider when looking at one of these laws, is the scope of the data that you're governing at all. So this is the topic of our last webinar. We spent an hour a few weeks ago talking specifically about how you define covered data, how you define data that you don't want to be included when it's been properly de-identified or sufficiently de-identified that it no longer poses a significant privacy risk. And that, of course, has an impact on research, which might be conducted on de-identified data and might fall within, fall outside of the governance of the privacy law at all. So that was the topic of our last webinar. I encourage you to go check that out. It's on our website. Everything in the middle, of course, has to do with the elements you see on the right side of the screen here. Transparency, access, opt-in consent, opt-out consent, and individual rights are kind of the core framing, the core elements of all of the proposals that we're seeing. Many of these are uniquely showing up in American proposals, and some of them are less common, but maybe better understood in European contexts, like data minimization and purpose specification. But all of them come from a report from the 1970s called the Fair Information Practices Principles, which in fact laid out all of these sort of elements of fair information practices. And really, in that sense, I would say all of these elements have American roots. So we're not talking about European principles that we're importing into US law. These are really things that have solid roots in American concepts of privacy. So to talk a little bit more about a couple of these and sort of the impacts on comprehensive privacy law, which I've outlined them here. Here's the report that I was referring to from 1973. I'm only gonna, for the purposes of time, and so that we can get to Q&A, I'm only gonna dive into a couple of them that that we consider either uniquely challenging for commercial research or not uniquely challenging, yeah, as the case may be. So the couple that I'm gonna dive into here are highlighted. I'm going to talk just briefly about transparency and access, opt-in consent, and the concept of data minimization, which, even though it wasn't traditionally a part of privacy proposals in the United States, is now starting to show up in a lot of proposals, including the California ballot initiative in 2020 and the federal proposals that we'll talk about. So to start us with something that I would consider relatively straightforward for commercial research purposes, transparency and access requirements are an example of an element of a privacy law that do not necessarily have to be in direct tension with commercial research. So collecting data and using it for commercial research purposes does not mean that an entity cannot reasonably comply with having transparent practices published in a privacy policy, for example. So most of the proposals that we're seeing towards a federal privacy law and at the state level include some basic transparency requirement for commercial entities. This usually means an obligation to disclose the categories of data that you're collecting and processing. But additionally, most of the proposals that we've seen require companies to state the purposes for which they're collecting data. You could, for example, state that academic research is an additional secondary purpose for which you're collecting data. This can be tricky with other obligations in privacy laws when you talk about purpose limitation, but we'll get to that in just a moment. For purposes of specifying the purpose, this should be relatively straightforward. And then in addition, most of the bills that we're seeing require some kind of disclosure of either the categories of entities that you might be sharing or disclosing or selling data to, or the specific entities to whom data is transferred or sold. So you see specific entities, for example, in Senator Cantwell's federal draft that was recently proposed. Senator Cantwell is the ranking member of the Senate Commerce Committee, leading Democrat. And you see categories of entities in Senator Wicker's draft that was released in the last couple of weeks. And Senator Wicker is the Republican chair of the Senate Commerce Committee. So, of course, specific entities might be a little more difficult to comply with. Categories could be, for example, academic researchers, whereas specific entities might require you to name specific institutions that you're partnering with. There are a lot of process requirements we typically see with transparency as well. You know, the policy has to be public, it has to be readily accessible, it has to be written in language that normal people can understand, for example, although this can often be in tension with being very specific, right? And then in addition to that, I don't even want to say almost, every privacy bill that we've seen introduced at the state and federal level contains some individual right to access data collected or held about them. Access requests typically have to be verified, meaning that you have to prove you are who you say you are, so you can't access someone else's data, which would be effectively a data breach. And access requests, in the words of one of my colleagues here at FPF, are often thought of as the way that you enforce all of the other privacy rights. Because if you don't know what data is collected about you, you can't possibly be expected to enforce your other rights, to opt in, to opt out, to delete the data, to object to processing. First, you have to know what's being processed. A couple elements of access requests that are tricky with commercial research. Inferences and derived data are sometimes a part of access requests. We see that, for instance, in the California Consumer Privacy Act. They're often exempted from portability requests, but show up in access requests. So the extent to which a company has to, for instance, disclose the inferences that they've made, the results of the research, might be tricky. And when we mention that requests typically have to be verified, I would say the main tension here with commercial research is that a lot of it is done on pseudonymous data. So when pseudonymous data, if it is not directly tied to a person's name or contact information, email, phone number, might still be included, likely is properly still included as personal information regulated under the law, but might be difficult to actually prove that it does in fact belong to you. So A good way to demonstrate that is that if I give you, for instance, my cookie ID or my advertising ID from my phone or a hashed MAC address from my phone, right? Any one of these pieces of information by themselves might be personal information, but there's almost, there are in some respects, not very many things I can do to really, really prove that it does belong to me. Even if I gave you my passport, you know, you would probably have to have some intermediary to show that the identifier came from my device. So, okay. Most of the proposals I've seen include some kind of rulemaking authority to address some of these issues. That's what California is in the process of doing now through their Attorney General rulemaking. And it's probably a good element to make sure that these sorts of elements remain meaningful over time. Okay. To take it from there to something that I think is much more directly in tension with most commercial research, we should talk probably a little bit about informed consent. First of all, opt-in consent is not an element of most US privacy laws. A lot of that is for First Amendment reasons, but for example, the California Consumer Privacy Act does not include any element of opt-in consent, except in a limited sense for children's data, but there are no opt-in consent provisions otherwise. There is a 2020 California ballot initiative that would require opt-in consent for sensitive data. And that I think is mirrored in some of the federal approaches too, which also include opt-in consent requirements for sensitive data. So that might include biometric data, it includes a lot of health data and wellness data, but wouldn't necessarily include sort of the range of other data out there, non-sensitive data. Similarly, a big misconception of the GDPR in the EU is that it's an opt-in consent law. It certainly isn't. Opt-in consent is one way to establish a lawful ground to process data in the EU, but the GDPR in fact provides 6 lawful grounds, which we'll talk about in a second, to process data, including other ways outside of consent. And a lot of people, I think, don't necessarily understand why this is in tension with commercial research interests. The biggest thing is practicality. So when you're dealing with very large data sets, which is a new, relatively new thing in the last 10 years related to the field of big data, if I'm dealing with millions of records, it's not going to necessarily be practical to get consent from every person in that data set. In other ways, even if I could potentially contact everyone, I might be dealing with a de-identified data set, I might be dealing with a pseudonymized data set, where it's no longer practical or possible to contact people to get consent. So either you would have had to get consent at the very beginning, or you've lost your chance forever, which means, you know, that it leans towards having very, very broad consent at the start of data collection, which may or may not capture all future possible commercial uses. It might be data sets where I don't have any existing consumer relationship. If I'm a commercial entity, for example, if a researcher would like to conduct an analysis of all of the public social media posts from the last 10 years, that would be difficult given there's no ability there to contact the people involved. The practicality is probably the most important thing. I also want to note that consent bias is a topic of considerable research and study in the research community. So there are differences between the types of people who tend to opt in or tend to opt out. Of course, we know that people vary in general in their level of trust when it comes to different institutions. And while that's understandable, if it affects the outcome of the research, then you no longer have a representative data set because you have excluded the people who didn't choose to opt in or the people who chose to opt out, right? So there can be bias in the resulting data set as a result of people exercising rights. The other example, before we move on to how some other laws deal with this, of a privacy principle that is often in tension with commercial research is data minimization. This is not something I think we would have put in a webinar 5 years ago because it wasn't an element of most US privacy laws, but it is, of course, a very important element from the Fair Information Practice Principles. And we are now seeing it in a couple of places. It's in both federal proposals that are now under consideration in the Senate Commerce Committee, and it's an element of the 2020 California ballot initiative that would raise the bar for the California Consumer Privacy Act, likely to be involved in an element, at least, of most state laws that state legislators are interested in passing in the next couple of years. When we talk about data minimization broadly, we're really talking about a few principles that often get conflated. Sometimes they work together. Sometimes they get written in ways that combine one or the two. We're talking about collection limits. Don't collect more than you need, basic principle, right? We're also talking about purpose limitation. So don't collect more than you need, but additionally, don't reuse that data for additional purposes after you've collected it, right? So collecting data for one purpose, say to provide a wellness app for consumers, and then reprocessing that data for additional purposes after the fact is generally what's meant by purpose limitations. And a lot of laws would restrict that in the absence, for example, of informed consent or in the absence of opt-in consent to those further purposes. Very important principle, bedrock principle of privacy law. With data minimization, we're usually also talking about ways to reduce risk. So you can reduce risk through de-identifying the data or making it less sensitive or less risky than it otherwise would have been, either to get out of the scope of the relevant privacy law or just to reduce risk, right? So you can, for example, if you are collecting geolocation data and you don't need it to be very, very, very precise, you can truncate that data very easily in a way that would still make it useful for the kind of analysis you're trying to do, but render it less precise and therefore less risky. So a couple of ways that the GDPR handles scientific research to sort of accommodate the tensions between these privacy principles and the objectives of commercial research is that the GDPR defines scientific research. So this is going to be an important element of most laws. You have to first define what it is you're talking about. Article 89 is where you can find the GDPR's definition of research. As you can see here, it's relatively limited. We're talking about archiving in the public interest, scientific or historical research purposes, or statistical purposes. The import under the GDPR of defining the type of data processing that you're doing as scientific research is that member states can provide escape valves, so to speak, derogations from having to comply with individual privacy rights, specifically the rights to deletion, objection to processing, and access because of the kinds of tensions that we're talking about, if they are likely to render the research impossible or seriously impair it. Like I mentioned a moment ago, the GDPR is not an opt-in consent law. There are 6 lawful grounds to process data. This is, again, a big difference between US and EU privacy law. In the United States, we tend to, when we're drafting a baseline privacy law, place very few or no limits on the collection of data in the first place and rely more heavily on individual control rights and opt-outs. In the EU, you have to first have a lawful ground to even collect the data, right? So it can be necessary to perform a contract, for example. It can be out of a legal obligation. The big one is consent, of course, and the GDPR places a very high bar for what consent means. It has to be affirmative. It has to be freely given. It's got to be unambiguous, for example. And part of the reason for that very high bar is because there are other lawful grounds to process data. Legitimate interests is a big one. Legitimate interests can mean more or less any valid commercial purpose or any purpose, so long as it is not outweighed by the impacts on the rights and freedoms of data subjects. So that means that you have to undergo a balancing test. In Article 5, you can see a purpose limitation principle of the kinds that we're talking about. So if you collect data for one of these lawful grounds, further processing that isn't compatible with those original purposes is prohibited. There is an exception to this, of course, written into Article 5, which is further processing for archiving in the public interest, scientific and historical research purposes, is per se compatible with those initial purposes. Okay, and then to take a look at some of the recent federal proposals that I mentioned just at the very beginning, and then we can turn to questions. The way that United States federal regulators or legislators have begun to address this issue is to draft research as an exception to the bulk of core individual rights in the privacy law. Now, you'll notice that these are not exceptions to the entirety of the law. So there's no reason, for example, that if you're conducting commercial research that you don't need to comply with data security obligations, right? It's still important to have reasonable security safeguards. But exceptions to the right to delete data, the right to consent to processing of data, and in some cases, the right to access that data might be a way to enable commercial research that is not otherwise regulated by the FDA or HHS or other sectoral law. On the other hand, you don't want it to be absolutely wide open to anything that someone might call research. And so what you see is a relatively narrowly defined definition of research that would have to be approved, monitored, and governed by either an IRB, which could be through an academic institution or a commercial IRB, for example, or a similar oversight entity, meeting standards promulgated by the FTC. And to take it back to what Rachel was talking about earlier here with ERBs, again, here are some of the possible legal elements that the FTC or another agency might consider when determining what the standards are that a similar oversight agency might need to meet. So some of the legal elements that you might consider if you were at the FTC promulgating these kinds of rules might be things like independence, how many members of that ERB are employees of the commercial entity trying to do the research, right? Probably not all of them is a good idea. You want to look at expertise, and you want to look at the stakeholders, the diversity of the expertise that you have on that ERB. You do not want, at the risk of insult to myself, you do not want an ERB filled with just lawyers, right? That would be a bad outcome. You may want ethicists, you may want philosophers, you certainly want technical experts, for example, de-identification experts. Patient advocates, I think, is a great recommendation. And then you might want to require those ERBs to consider things like anticipated benefits to society. Is the benefit going to solely accrue to the commercial entity, or is there a broader societal benefit? Keeping in mind that there's almost always going to be a commercial interest of some kind, right? You want to consider steps taken to minimize risks. You want to consider re-identification attacks over time, which is an ongoing process. You want to consider risks to autonomy. If you can get consent, perhaps it's a good idea to get consent, right? And what is the impact of not being able to get it? If you can offer deletion rights without seriously impairing the research, it's the right move to offer deletion rights, right? And another thing you might consider is whether the results will be published. And a lot of this lines up, I think, Rachel will correct me if I'm wrong, a lot of it lines up with what existing privacy review boards and IRBs already consider.
Yes, definitely. And then to add to that, also considering information firewalls that should exist between the entity that might have financial interest in funding the research and then those who are actually engaging in the conduct of the research activities. But every element that you've mentioned, Stacey, today is definitely incredibly important and definitely aligned with the ethical tenets that are already in place under existing legislation that oversees the conduct of research activities across traditional settings.
Great, thanks, Rachel. We're going to stop here for questions, and I'll flag that we have a list of recommended readings that we're also going to be posting on our website. A lot of our content is from some very helpful resources from the European Parliament Research Service, which is similar, I understand, to the Congressional Research Service, but for the EU Parliament. and from a couple of really great scientific legal scholar papers that have been published in the last couple of years. So we have a couple of questions in the chat, but I think in order to facilitate some of those, we're going to turn off the recording so that we can post this online. So let me just say to everyone watching this after the fact, thank you so much for joining, and shoot us an email if you have questions.